Hello, Ibus 340 students. Just in case the decision is to have a second board meeting, which is really what I hope happens, what I'd like to do is do an online lecture here for a big chunk of the material to make sure that we get through enough material that I can have an exam at the end of the year. We finished talking about municipal contract law or domestic contract law, and we were getting into international contracts, and that's governed by the International Convention on the Sale of Goods, and so I'm going to run through that material right now. It's very clear in the slides, so you should be able to follow along with the slides and my lecture. Slide 96 is where it starts, and it says that sales must be international. That means there has to be two countries involved in this type of dispute, and the selection of the law will be according to the International Convention on the Sale of Goods automatically if the countries are signatories. If you want to opt out of that, which Americans do quite often, then you have to put in a choice of law clause. And it wouldn't be a bad idea to say that the choice of law is the law of the United States of America to the exclusion of all conflicts of laws, including but not limited to the exclusion of the International Convention on the Sale of Goods. So it gets a little complicated, but you can do that. It has to be for the sale of goods. There are goods and services which can be covered, but the sale of anything other than goods is prohibited, and we have the definition on slide 97 where they talk about mixed sales. Mixed sales means if you're selling some things that are covered, but you have the sale of services, then it won't be covered by the International Sale of Goods, and then you've just got to go to the regular courts or arbitration. We have the illegality and incompetency. This was on the exam last year, and I suspect it would probably be on the exam this year. In some way, we have offer, acceptance, consideration, and intention to create legal relations, all covered by the International Convention on the Sale of Goods. But the countries had such widely disparate laws with respect to illegality and the idea of capacity that those are not covered by the International Convention on the Sale of Goods. So if you have a dispute with respect to legality of object or something like that, the International Convention on the Sale of Goods is not how you would fight it out. You would duke it out in a municipal court or arbitration. The parole evidence rule, which is a common law rule, and we're not going to get into it in any great way, but what it means is that any verbal discussions between you and I, not reduced and put into the contract, will not be allowed to come in to either contradict or dismiss the contract. The parole evidence rule is a common law concept which is excluded from the International Convention on the Sale of Goods, and so it doesn't apply. With respect to offers, there is in one of the articles a definition of an offer, and there's a definition of revocation in there. There's a definition of consideration, and all those are in the Act, which, if this is on the exam, you will either be entitled to bring in with you, or I will attach it to the materials on the exam. The one thing to remember, though, is if I make an offer to sell 100 peak performance pontoons to you, and I say it's open until 5 o'clock Friday for you to make that decision whether to buy or not, under the common law, I can phone you up on Thursday and revoke. And you say, hey, wait, no, you gave me until 5 o'clock Friday. And I go, yeah, I know, but that's a gratuitous promise. I can revoke at any time before acceptance. You haven't accepted yet. I revoke. Well, under the Sale of Goods, the International Convention on the Sale of Goods, they say we have this thing called firm offers, which if I say I give you until 5 o'clock Friday, I have to keep my offer open until 5 o'clock Friday. So that's an absolute distinction from the common law. If I said I'll sell you my 100 pairs of my skis by 5 o'clock Friday, and you wanted to have that time period to make your decision, at common law you would have to pay me some money to keep it open, because then we would have what's called an option agreement, and that would be a binding contract preventing me from revoking before Friday. But under the International Sale of Goods Act, we have the ability to just say, I'll sell you 100 skis until 5 o'clock Friday, and you automatically have what is tantamount to an option agreement. Okay, the mail rule. The mail rule in Canada and England and Australia, common law provinces, says that if I make you an offer by mail, the acceptance occurs when you put a properly addressed stamped envelope into the mailbox. So if you were in Australia and I mailed or couriered an offer to you, then you could accept by mailing it if I mailed it to you, or couriering it back to me if I couriered it to you. And the contract would come into existence in Australia at the time that you mailed that letter or you gave the return letter to the courier. Even though in the meantime I might have sent you a letter trying to revoke, my revocation would be too late. The mail rule does not apply to the Convention on International Sale of Goods, and we adopt the civil law rule, which says an acceptance is only effective when it reaches the offeror. So the Australian company mails the letter of acceptance. It comes when it arrives. We have a contract. But in the meantime, I call you and I revoke. I haven't received your letter yet. Bingo, no contract. Okay, we have the seller's obligations and the buyer's obligation. The seller's obligation is now I'm going to read this, to indicate the, no, hold on, I'm going to back up. Sorry for that interruption. I completely lost my train of thought and my place on the slides, but just going back to it now, I'm talking about the seller's obligations, and there's a number of them, and that could be a Part B exam question, for example. It's the place of delivery, the time of delivery, the turnover of documents, the conformity of the goods, and that sort of thing. So the time of delivery, it just means if there's a specified time, we have to get it there on time. The place of delivery is obviously the place it's supposed to arrive at, determined by the quote. Then there's the delivery of the documents. In a letter of credit, there's at least 5 that have to be there, sometimes more, and so those documents have to be turned over so that the transaction payment can be completed if that's how it's happening. And then the goods have to conform with the specifications or with the sample provided, and that sort of thing. And they have to be properly packaged. So it's listed right there in slide 99. And then the buyer's obligations on the other side of the coin is to pay in the manner prescribed and also to take delivery of the goods. Now, what does that mean? I had a client who sold goods to a business, furniture to a business in Puerto Rico, and payment was made by MasterCard subject to delivery, and the goods went down FOB, their particular place of business, and the goods arrived in Puerto Rico. They were in bond, they were taken out of bond, delivered to the residence or the office, and the businessman said, I refuse to take delivery. So the goods went back to the warehouse. Of course, they're no longer in bond, so they were either destroyed or disappeared. So my client did not get paid, nor did he get the goods back. And we checked the MasterCard agreement, and it says if delivery occurred, then payment had to be made. But what he did was he said delivery didn't occur because I didn't take delivery, and so I canceled my MasterCard payment. We went to court on this one, and in court we said delivery doesn't mean they have to actually physically take it from you. Delivery means we have to deliver it to the place of business specified in the documents, and we had done that. So because delivery had occurred, the transaction was reversed and my client did get the money. So they have to pay in the manner prescribed and take delivery. Now, the International Convention on the Sale of Goods also specifies the buyer's remedies and the seller's remedies, and then some mutual remedies that they both have. The buyer's remedies, there are 5 of them, and gosh, there's a 5B exam question, for example. Specific performance, they actually have to specifically perform that particular contract. It means they can't say, well, no, we no longer want to give you the goods because they're much too valuable, pay money instead or something. They can't do that. Avoidance, if the buyer doesn't get the goods, they can then say, sorry, we're avoiding the contract, which means bringing the contract to an end. They can reduce the price. They can say, okay, we'll accept the goods, but we want some compensation for damage or something. And they can refuse early delivery. If they don't have warehouse space to store it, then getting them before they need them is bad, and so they can refuse early delivery. And they can refuse excess quantities. Well, we sent you 120 skis, but we only charged for 100, so just accept them and pay for them later. They can say, no, we're not refusing, or we're refusing those excess quantities. So those are the buyer's remedies. The seller's remedies, specific performance. Again, we've delivered the goods, you have to pay us the money. We will not take other goods in exchange, or we will not take a credit, or whatever, you have to pay us. The seller also can avoid the contract for a breach of it, and the seller can also say, listen, we get to sue you for damages because when you ordered the goods, there were missing specifications that we didn't know about, and so that caused us a problem. So that, and then of course there's remedies that they both have, and that's a suspension of performance, and this allows for the force majeure concept that we've talked about, and then anticipatory avoidance, which means I phone you up and I say, look, don't deliver the goods because we cannot pay you, so you don't deliver the goods, and then bingo, payment arrives, and they say, where are the goods? You're in breach, right? So you have the right to anticipate their breach and not send the goods, that sort of thing. Okay, they're not too important. What is important, though, is the concept of mitigation. No matter what happens under the common law, under the civil law, or under the Convention on the International Sale of Goods, is that if you have suffered a loss or a breach of contract, then you must mitigate your damages. So I'm sending you the goods, and you contact me and you say, guess what, we're insolvent, we can't buy them. I can sue you on, perhaps hoping for some sort of insurance claim. And then when we get into court, the judge says, okay, the goods, what happened to them? Oh, well, they were en route, and they got destroyed, or whatever, or there was perishable and they perished. What you have to do is you actually have to try to minimize your damages. There was a case about grain, corn being shipped from Greece to England, and right after the shipment was sent en route, the seller found out that the refrigeration system had failed in the ship, and by the time it got to England, the corn would be ruined, and so they diverted to a port close by and sold the corn at a much lower price, and then sued for the amount that they should have gotten, but on the basis that the insurance should cover it because title had transferred. But what they had done is they had sold for a portion of the money, so they reduced that from what they're going to get. So an easier example would be if I was employed by you for 9 years and I was supposed to get 9 months' pay in lieu of notice to if you let me go and you only gave me 2 months, well, I've suffered 7 months' damages. If I just sued you for the 7 months' damages and got into court, the judge would say, well, what did you do to mitigate your loss? And you say, oh, well, I got a Coca-Cola and I put some rum in it and drank rum and Coca-Cola and cried. They would say, well, that isn't mitigation. Did you try to get a job? And you say, well, Yes, in actual fact, I sent out 300 letters to various businesses trying to find a job. I went to 9 interviews. The market's down. I couldn't get a job. Then you get your 7 months' pay. So you have to try to mitigate your loss, and that's covered in both the common law, civil law, and under the International Sale of Goods Act. Which brings us to the topic of excuses for non-performance. There is the force majeure concept, and there is the common law concept of frustration. Frustration is not part of the International Convention on the Sale of Goods, so you have to use the civil law concept of force majeure, which makes a whole lot more sense, and that's suspension of performance until performance can occur. All right, so that's the International Convention on the Sale of Goods, and now we're entering into another topic that's a little more straightforward, and that is the concept of payment risks in international trade. So financing international trade is really the overall topic. The Bank of Nova Scotia provided slide 103, which shows the risk barometer in international sales. And the risk is open account, that's pay me on 30, 60, 90 days, here's my goods. And then 90 days later, you're waiting and you haven't been paid yet. Another month goes by and you call them up and you say, hey, you haven't paid me yet. And they go, well, didn't we let you know we're insolvent or something like that? That's obviously the highest risk because you're sitting out there waiting for 30, 60, or 90 days to actually get your money. International sales are seldom, if ever, on that basis unless there's been a long relationship between the parties. The next one is documentary credits or collection. It's the exchange of documents and the exchange of bank drafts and in support of those documents. And again, it's very, very risky because there could be problems with the documents and there could be fraud with the bank drafts or the bills of exchange, as they're called internationally. And so we're not even going to get into that. Just know that documentary collection is one way to do it. You collect on what amounts to a check, and checks can be bad, or the check, by the time it's processed, the business has gone insolvent, so it's incredibly risky. Letters of credit, obviously a better way to do it. Letters of credit confirmed, much better way of doing it, or pardon me, letters of credit than irrevocable letters of credit, safer. Irrevocable letters of credit confirmed, even safer than that. And then the last is cash in advance. But quite frankly, cash in advance is the opposite side of the coin from open account, and both of those are risky. One is risky for the seller, and the other is risky for the buyer. And what's the best? Well, irrevocable letters of credit confirmed. Still, there are risks involved in international trade. There are commercial risks, and there are political risks, and you have to know these for the exams. I mean, you should know them and understand them and appreciate them for work purposes, but these are really good exam questions. Commercial risks, there's the risk of insolvency. That's the open account one, where the buyer becomes insolvent and unable to pay. There's a repudiation, where the buyer, for some reason, refuses the goods and repudiates the contract. There's default, where they just decide not to pay you by the due date, and that could cause you all sorts of conniptions, whether they eventually pay you or not. And then there's the foreign currency exchange transactions, risk the fluctuations in the value of the currencies, and that was really well addressed by the letter of credit team. What you do then is you make sure that you hedge your currency fund. And then there's documentary risks. Even with a letter of credit, we have the problem that we have to provide them at least 5 documents, and if there's any errors on those documents, the rule of strict compliance kicks in. The courts will not apply de minimis non curat lex, which means if there's a small error, you have to perform the contract. As far as letters of credit is concerned, they say, hey, there's a mistake in the documents, you don't get paid. So those are the commercial risks, and then we have what they call the political risks on the other hand. And believe me, in this uncertain world that we're living in now, the political risks are very, very considerable. You have the possibility of war, a lot of business transactions in the Middle East. A war in one country can spill over and cause problems in another country. You have something like a cruise ship and you're going to Constantinople, and then the Turkish government shoots down a Russian jet, and the next thing you know, you're in a war zone. There's civil disturbances, which is considered different than war. Civil disturbances is some sort of an uprising or riots or something like that, and that can disrupt the flow of goods or the flow of currency even, and cause non-payment. Then there's foreign currency exchange conversions. The foreign currency just becomes not available, and this is becoming less of an issue. But for example, not too many years ago, and Yiling, if you're if you're watching this video, I apologize again, but for the longest time, the People's Republic of China did not have enough U.S. dollars. And so they would often freeze the currency so that no U.S. dollars could be paid out of the country. And so if you had an arrangement where you're getting paid by letters of credit and it was to be in U.S. funds, they would stop the funds by saying there's no U.S. currency available. And it may not prevent you, or it may not result in you not being paid, but it could certainly delay substantially the date of payment, which may be sufficient to drive you into insolvency. And then the last thing is there's permit problems, and I think I might have already discussed this. Yeah, I'm pretty sure I did when Canada put that prohibition on toys coming in from the People's Republic of China. Because they had lead paint on it, the People's Republic of China in retaliation said, oh, we're not taking any pork from Canada because there's a mad pork disease, which doesn't exist, but they said that it did. And so what they were trying to do was hurt our economy sufficiently that we would give up stopping the importation of toys with lead paint on them. And so businesses couldn't get licenses to export pork, and it was quite a substantial financial hit for Canada. And if you were in the pork industry, bingo, you're in trouble. So if we needed a permit in order to export our skis to Australia, for example, and they said, well, that's it, those are no longer available, then our business would take a financial hit. All right, methods of payment. Cash is tender of performance. A buyer must seek out their creditor. So in other words, you're sending me the goods, I have to tender the payment in the manner prescribed. You have to be really careful because some unscrupulous people would say, I'll sell you this for $10,000 US. So you send them, or you try to pay with a $10,000 US bank draft, and they could say, hey, we said $10,000 cash, and that's a bank draft, we're not accepting that. You haven't tendered performance, you're in breach of the contract, which sounds stupid, but it has happened. So the other way is letters of credit. We've already talked about that, and I think we've gone through screens 106 and 107 because the letter of credit team did a good presentation. I wanted to make sure that we just covered those so that we eliminated the need to do so. Just one more comment on the documents required. A certificate of origin, we know what that is. That's required in a letter of credit. The export license, perhaps if it's food. Not an issue for us though. So ours would be a certificate of origin, probably a certificate of inspection, whether G'day Mate's paying for it or not. The issue is that we have to make sure that it's one of the documents delivered. It has to be a commercial invoice. That's just the bill of sale. Okay, that's all it is. And then the bill of lading is the document provided by the shipping company that keeps track of the goods en route, and we have to provide a bill of lading. And then we have to have a marine insurance policy. They may be paying for it, we may be paying for it, but it has to be part of the package. Otherwise, the bank goes down the list. Oh, no insurance policy here, we're not paying out. We've done this rule of strict compliance, and we specifically talked about how the bank act, or the banks are not involved in the contract at all, and so any fraud that's involved in there does not affect their obligation to pay out. And then there's a risk management footnote right at the bottom of slide 109, which says that you want to make sure that you check the LC to make sure it's irrevocable. You check the status of the issuing bank and maybe ask for a confirming bank. And then as soon as the LC is delivered, you look to see what has to be provided and make sure that the terms reflect your agreement with them. Okay, the slide 110 just talks about the various parties advising bank, confirming bank, issuing bank, and beneficiary. And then we get into the trade terms. Trade terms, we're going to deal with the International Chamber of Commerce's Incoterms, because that's the predominant terms that are now used in international trade for certainty. And the trade terms just describe the time and place where the buyer is to take delivery. And delivery means it could be delivered to the Port of Vancouver going to G'day in Australia. We're finished with delivery there. We send them the documents. They pay us out. The goods and the ship are at their risk. And so delivery is where we deliver it, and the risk, who has the risk. Okay. Incoterms we know is just their standardized trade terms, and there's a slide 113 which looks complex on the surface of it, but it really gives you the letters, the FAC and or FCA and the FAS and CIF, and tells you where risk passes, and unless specified otherwise, risk passes and the other party becomes required for payment. The CIF and CF designations, if this was a one-off for G'day Mate, they would say, well, we need the freight, like the shipping, taken care of, and we need an insurance policy, but we don't know how to do that, and we don't want to do that. So a CIF policy, for example, would be, we agree to pay the cost of the insurance and freight, but hey, Peak Performance Pontoons, you do it all. You find the ship, you find the freight forwarder, you get all the documentation. We'll pay for it, but we want CIF. So they pay from the Port of Vancouver to Australia, and they pay for insurance, but they put the onus of getting those things on us. Okay, so I think you just look at that particular screen, and maybe if there's any questions, we can go over it in class. So that brings us to carriage of goods by sea, and I think this gets a little on the complex side, so I think I would probably want to try to handle that in class. What I'm going to do is I am going to look at the time available. I'm going to talk with you on Friday and in our Friday class, and then I'll say we can or cannot actually have enough time to do this, and if there's not enough time, then then I will do a video lecture to cover this material, and then I will make sure that on the exam I take into account that it was a video lecture, and I will not weight it as heavily as the other parts. Anyway, that's about gosh, I'm not sure how long, whether that was just 7 minutes or 38 minutes. It must have been 38 minutes. So that just gives us some pickup time and allows us more time to cover the material, have a board of directors meeting, and still do a review before the exam. So thank you very much.